All right, we are live. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth. Draw near, give your attention, you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Good morning.
Good morning.
Welcome to the Appeals Court.
Thank you, Your Honor.
You'll be our first case for the day. The panel consists of Judge Sachs, who I believe he's to my right. I think he might be to your right as well. And Judge Shin, who is to my lower left, and hopefully that's the same for you. And my name's Judge Desmond. We're gonna keep this as normal as possible. There'll be 15 minutes per side with no rebuttal. You can trust that we've read your papers and are fully apprised of the record. And with that, I'd ask that we get right into it. So, Attorney Lindmark?
Yes. Good morning, Your Honors. I'm Attorney Pamela Lindmark. I am here arguing on behalf of Mr. Osvaldo Jimenez-Torres. This is a case involving an alleged abduction of a female victim. He was found not guilty of many of the numerous charges initially brought out against him, but was convicted of kidnapping and assault and battery. There are two issues brought forward in our brief, and I hope to touch upon each briefly this morning. On issue one, we raised a question of the sufficiency of the evidence. It's our position that the Commonwealth did not meet its burden of proof, proving either one of these two remaining charges beyond a reasonable doubt.
Would you agree, Attorney Lindmark, that this case rests primarily on the credibility of the witnesses?
In large part, yes, Your Honor. And I would just also add to that, it appears the jury did side with Mr. Jimenez-Torres and much of what he had to say in his testimony, just on the basis of the results. Again, our argument is that the evidence was insufficient. The Lattimore analysis would apply and the court would view the evidence in the light most favorable to the Commonwealth. Could any rational trier of fact have found the essential elements of these crimes beyond a reasonable doubt? We argue no. The evidence that was presented, all of it was circumstantial at best. The alleged victim did testify, and it appears her testimony was in direct contradiction to that of Mr. Jimenez-Torres, who also testified.
Is it your position that because it's circumstantial evidence, it somehow undermines the value of that evidence?
Well, circumstantial evidence can be accepted and can in some cases be enough to prove guilt. Clearly that's shown in the case law. However, in this case, we would argue it simply was not enough. There were too many pilings of inferences. We're quoting the Swafford case when we say that piling of inference upon inference is not allowed. That these two individuals appear to have had sexual relations is established by forensics, but beyond that, it's purely conjecture as to how they came together on this occasion, how long they stayed together, and what happened while they were together. He tells one version of the events and she another. My colleague, the Commonwealth has raised the issues which in fact are quite interesting, but I did not mean to raise in our argument on appeal, the issue of factually and legally inconsistent verdicts. It was not our intention to raise those on appeal, rather in support of our position, again, that there was insufficient evidence in this case, stressing that even the jury seemed to have issue or to have struggled with this issue of evidence. And in some, even viewing the evidence in the light most favorable to the Commonwealth, there simply was not enough, too many intangibles, too many unknowns and conflicting testimony. And that's the basis of our argument on issue one.
And so do you agree then that factual inconsistency is not a basis to reverse the convictions? Assuming
yes,
okay.
Yes, we would. To issue two, where drawing into our analysis the issue of an improper closing argument. The standard of review here, since there was no objection, is was there a substantial risk of miscarriage of justice? Our argument is there were a series of improper statements and observations, the sum total of which were very prejudicial, so prejudicial as to require reversal. The most egregious of these would be the prosecutor improperly accusing Mr. Jimenez-Torres of lying, of being a liar, of his testimony consisting of a series of lies, denigrating his character and talking about his testimony again, over and over again, as just lies.
Is it the word lies?
The problems that we've outlined in our brief may not seem to create.
Attorney Lindmark, is it the word lies that you quarrel with? Isn't there some evidence in the record that, if believed, he did indeed tell some untruth?
Well, there was some issue as to what his name was. In fact, he did have a baseball name, which was different from the name that he has on file with the state of Massachusetts. And that was not, in fact, a lie, although it was assumed that it was.
What about the mentioning of Nancy?
Example, if that's what you're referring to.
What about his mentioning of Nancy to the police officer? And he seems to suggest that he never said that.
Well, again, there's contradictory testimony as to that at trial, and there was evidence from the police officer and from the alleged victim that he called her Nancy and seemed to be mistaking her for his former wife. But even if that were to be true, that would not be lying. That would be his mistake, we would argue. So in sum, I would just like to say to the court that Mr. Jimenez-Torres is a man who's still serving a 4.5-year sentence on these verdicts. He's been denied parole because he refuses to admit any responsibility for something he says he did not do. He very strongly wished to have this appeal proceed, and we respectfully request you reverse his convictions based on the argument presented to you today.
Thank you kindly.
Thank you. May it please the court, Kenneth Steinfeld for the Commonwealth. The victim's testimony in this case is not circumstantial evidence. It is direct evidence. As Lindmark said in her brief, and again this morning, that this case is wholly dependent on circumstantial evidence, when that is simply not the case. When the victim says, this happened to me, this happened to me, this happened to me, if the jury believes that, then that was sufficient to prove the crime. The jury needed to draw no inferences from her testimony. So this is not a circumstantial case. This is not a speculation case. And the verdicts were in fact the product of a very conscientious jury. And I cite the Grinkley case in my brief, which talks about verdicts that are deeply rooted in the evidence. And that's exactly what this case was. For each of the crimes that they convicted the defendant of, there was corroborative evidence from witnesses other than the victim. For each crime that they acquitted him of, there was no corroboration. In other words, when the jury only had her word for something, they discredited it or failed to believe it beyond a reasonable doubt. Whereas for the kidnapping and the assault and battery, hand on breast, there was other evidence. In the former, there was the evidence from the detective who saw her mouthing, help me, from the window. And then she came running down frantically. So that corroborated her testimony that she had been kidnapped. And as to the assault and battery of her breast, she said that during the sexual assault examination, she discovered that there was bruising to her breast, and the medical record that I've submitted as page 5 of my supplemental record appendix even says there is trauma to the chest area based on x-rays. So this jury was incredibly discerning, I would say. They had a somewhat problematic victim who was shaky on some points, strong on others. And there's no inconsistency, factual or otherwise. And there was an abundance of evidence of kidnapping. I'm not going to go into that very much. It's set forth in my brief. But if you just believe the victim's testimony, that is more than enough. In fact, if you just believe the detective's statement, the defendant even said to him at one point, "I tried to prevent her from leaving." So you have a statement from the defendant himself on top of the victim's statement that he placed a restraint on her movement, which was sufficient for her to prove kidnapping. I'm sorry, for the Commonwealth to prove kidnapping. As to the closing argument claims, as I say, I believe all three of the statements that she complains of were entirely proper. And even if not, there was certainly no prejudice and no substantial risk of a miscarriage of justice in light of the number of acquittals. The jury acquitted her of the aggravated portion of the kidnapping, aggravated rape, strangulation or suffocation, attempted murder by strangulation, assault and battery by placing his hand on her buttocks. And so by those acquittals, that shows that this jury was in no way overwhelmed or prejudiced by anything that the prosecutor said in her closing argument. I don't have anything else to add to that, and what's in my brief. I'd be happy, of course, to answer anything that the court might wish to ask.
Thank you. Any questions from the panel? I think we understand both positions. Thank you very much. Team P 1255. Attorney DeMello.
Thank you. Your Honor, Kevin DeMello on behalf of the defendant, Kenneth Dykens. The verdict in this case was a miscarriage of justice because the Commonwealth failed to present sufficient evidence beyond a reasonable doubt that the defendant was impaired while operating a motor vehicle. And I think the weakest part of the Commonwealth's case at trial was the question of intoxication. The only evidence of intoxication produced here was that the defendant was found extremely drunk and that the car was found crashed. But under these circumstances, where the defendant is found an hour later, a quarter of a mile to a half a mile away, the defendant suggests that there's at least an equal inference that he became drunk after the car crash, especially when he was found drinking a bottle of wine and half to a quarter of that bottle of wine is gone. There's no admission as there was with regard to operation in the letters. In fact, the letters say just the opposite. The letters say that he wasn't driving drunk. When you look at the case law that's cited both by the defendant in this case and the Commonwealth in this case, the Bellevue case, the Lavendier case, the Gallagher case, Chabot case, all of those cases, they're all very different from this case. And the way that they're different.
Don't the letters support an interpretation that there's a consciousness of guilt on behalf of Mr. Dykens?
Well, I think that the defendant would quarrel with that for two reasons. One, he's asking Ms. Radigan to testify truthfully. He says that repeatedly. And second, what he's asking her to testify to is actually that she saw Mr. Dykens and this person, Michael, leave that morning together. I don't think when you look at these letters very closely, I know the Commonwealth contends this, but when you look at the letters very closely, I don't think they actually say, please tell the jury that Michael was driving, or even that Michael was driving that morning. If you look at, in my record, in the record appendix for the defendant on RA 29, it says specifically, you testify that morning, you served me and the kid, Mike, breakfast. He was the one driving, he left the scene and walked alone. So if you look at that closely, what he's actually asking is that you testify about what happened at breakfast, not what happened with who was driving the car.
And in your view, there's no other reasonable view of those letters?
Well, I guess there is a reasonable view, but what I would suggest is that, the case law is clear that when there is an equal inference of one thing versus another, that's not enough to support beyond reasonable doubt standard. And here, there's at least an equal inference that Mr. Dykens wasn't the operator and that he wasn't intoxicated while operating the motor vehicle. There's other evidence in this case. We've been talking about the other driver at the scene. Also, the fact that Mr. Dykens was found without any car keys on him. He's not the registered owner of the car. He's not a licensed driver. all of these facts suggest that he may not have been the person driving, that he may have asked Michael to drive because he wasn't licensed. For all we know, he may have asked Michael to drive because he was impaired. There's just not enough evidence in the case to determine one way or the other what happened here under these circumstances. As far as the corroboration issue goes, I would point to the Leonard case that I cited in my brief. And in that case, there are two people found in the car. There's a dispute about who the driver is. And the other person, not the defendant, her cigarette butts were found in the passenger seat. And she's saying to the defendant, give back the keys. Even that, in that case, wasn't enough to corroborate the defendant's admission that he was driving. So I would suggest that in this case, we have even less than that, and there isn't sufficient corroboration.
I'm sorry.
Go ahead, I'm sorry.
You seem to be focusing your argument on the trial record. Do you want to touch upon the grand jury presentation at all?
I would touch upon it briefly. I do recognize that there's a lower standard at the grand jury for probable cause, but I would also suggest that there's even less evidence at the grand jury stage. You don't have the letters with an admission. You don't have Ms. Radigan's testimony. You do have that no keys were found on Mr. Dykens. You do have that he was found about an hour later, far from the scene. You have that he's not the registered owner of the vehicle. Based on that, the defendant's position would be that the Commonwealth didn't produce enough evidence at the grand jury level to support probable cause that Mr. Dykens was the driver or that he was intoxicated while driving.
The motion to dismiss the indictments was directed only at the element of operation. Is that correct? And not at the element of intoxication?
I believe that's correct.
So wouldn't that under criminal rule 13C2, and I think there's a statute on this as well, 277-47A, that any challenge to the indictment needs to be brought prior to trial? So can we consider at this stage whether there was sufficient probable cause on the issue of intoxication, or is that essentially waived and reviewed for substantial risk?
I actually don't know the answer to that question. I'd be happy to research that and submit a supplemental memorandum if the court's inclined. But that's not an issue that sort of came up in my consideration of this case. I do think the grand jury issue is probably the third most important issue that I would bring up here, with the second most important issue being the testimony regarding the airbags. The prosecutor's closing argument about the airbag deployment prejudiced the defendant in an otherwise closed case because it was not supported by expert testimony, and frankly, it was factually incorrect. And I'd like to read the sentence that the prosecutor states. He says, and in fact, you heard testimony that the passenger airbag probably wasn't even activated. Well, that the passenger airbag didn't go off and that it would only go off if somebody's in it. That's what activates it. And that's on page 145 of trial volume 3. This testimony, this argument is improper because it lacked any expert testimony behind it. It's clear from the case law that where...
Can I just break in on you there? It may have required expert testimony to support it, but once the testimony was admitted without objection, the investigator's testimony, it was in for all purposes. So I'm wondering if what you are attacking is really the prosecutor's argument, which was based on admitted evidence, or whether you're saying that the admission of the evidence from the lay investigator was itself a substantial risk of miscarriage of justice.
Well, I do think that there's a problem with this testimony that was admitted. It was, first of all, let's point out that it was brought out by the prosecutor, not by the defendant. The defendant probably should have objected. Does that rise to the level of a miscarriage of justice that he failed to object and it was let in? I'm not sure. I think it's a close question. That being said,
if it was in, but if the evidence was in, then how is it improper for the prosecutor to make an argument based upon it? I mean, the prosecutor didn't go beyond the evidence. Because
the prosecutor needed expert witness testimony, and that testimony did not come from a qualified expert. It's clear from the case law that airbags are governed by a complex system that requires expert testimony to understand. It's beyond the comprehension or the common experience of a normal juror. And likewise, it's beyond the common experience of this investigator who's not an expert in this technology. So the prosecutor asked these questions, brought this stuff into evidence, even though it wasn't proper, and then made it much worse by making this improper prejudicial argument that because the airbag in the passenger seat didn't go off, there must have been no one in the passenger seat. Well, the other problem with it is it's actually factually incorrect. I mean, even just looking at the facts of this case, you find that the curtain airbag on the steering wheel side deployed, but the steering wheel airbag didn't. So just because someone's sitting in the driver's side doesn't mean that airbag's going to go off. Likewise.
So wouldn't the jury have realized the same thing and said, well, if the driver's side airbag didn't deploy, when we know there must have been someone in the driver's seat, the fact that the passenger side airbag didn't deploy doesn't tell us anything about whether there was someone in the passenger seat. So the inference that the prosecutor was asking the jury to draw was a very weak one. And in that light, I'm wondering how it could have created a substantial risk of miscarriage of justice.
Well, I agree that the prosecutor's argument was undermined by the facts of the case, but here it's an issue that went to the heart of the case, the question of who was the operator. And the fact that the jury could have listened to this argument and misused it to believe that the defendant was the operator when there really was, a close question on that issue is really where the prejudice is. And, again, if this was a case where there was a lot of evidence of operation, it might be different. But this is a case where it's a hotly disputed issue and it's a close call based on circumstantial evidence. And in that case, the danger of unfair prejudice is much higher. And so that's why I think in this particular case, the way that this argument was made, it was improper and it unfairly prejudiced the defendant. If there are no further questions, then I would just rest on my brief.
Thank you kindly, Attorney Doyle. Attorney Baldwin.
Good morning again, Your Honors, and I apologize for the background. I was in the middle of setting everything up, so sorry if it's difficult to see me with the light behind. In terms of the issue of impairment and intoxication, the defendant here displayed all the classic symptoms of intoxication: glassy, bloodshot eyes, odor of alcohol, unsteady. He was unsteady on his feet. You had, in terms of the trial evidence, you had 3 state troopers testify.
I don't think your brother disputes that. The question is, all that was discovered sometime after the fact. He was never in the seat of the car. Nobody saw him around the time of the accident driving the car. And what happened sometime after is not the issue at trial. So I don't think your brother disputes that he was drunk or that he was found drunk.
And I certainly agree with that. So, and I think the key issue, I believe, would be operation here. And I think that's the main issue. And when it comes to either impairment or operation here, as I stated in the brief, there's no doubt that the evidence here was circumstantial evidence, but you can convict a defendant based on circumstantial evidence. All that matters is that the inferences drawn from that evidence are reasonable. And there certainly were reasonable inferences here. You had testimony that the defendant took his girlfriend's car without permission earlier that day. You had his girlfriend, Miss Radigan, testify that he was driving the vehicle at the time. You had Trooper Foley, I believe, Trooper Foley testify that a half an hour before police responded to the scene, saw the same exact car driven by a white male with no other passengers in the car. That evidence.
And no evidence of erratic operation at that time, is that correct?
That is correct. And I believe, as the prosecutor stated in his closing, sometimes even a blind squirrel finds a nut every now and then. So when the trooper passed by, that is correct. He did not testify as to any erratic driving. But the issue here is, again, operation. The additional circumstantial evidence was that when Trooper Doherty showed up with the canine immediately, there was a strong human odor. The canine jumped out of the car, followed a single set of footprints from the scene of the accident to where the defendant was found. During the search with the canine, which was testified to be about an hour, and so this is between 1 a.m. and 2 a.m., no other sets of footprints were found, only one, and no other individuals were seen in the vicinity. So I think it's all of those pieces together certainly provide reasonable inferences that the defendant was the operator of this vehicle. And then, of course, we come to the letters, where there are admissions in those letters, where he says, I was driving. I'll admit I was driving, but I won't admit to OUI or DUI.
So the evidence that he was operating at the time the car went into the guardrail might be sufficient. The evidence that he was intoxicated when he was found an hour later might be sufficient. But where's the evidence that he was intoxicated at the time the car went into the guardrail?
The evidence would be the half-empty bottle of wine that the defendant had on him when he was found, when he left the car.
So are we supposed to assume from that he had drunk that half bottle of wine an hour earlier before he crashed the car?
I think it would be reasonable to infer that based on the defendant's, again, you had troopers testify, one of them said he was a 10 out of 10 in terms of...
Sure, he was intoxicated at the time, but the key issue is, was he intoxicated an hour or so earlier when he was behind the wheel?
I think it would have been reasonable for the jury to infer that he was, considering the testimony that this was again, not a small man. He was about 6 feet 2 inches. I believe he was described as being over 220 pounds. I think it would have been reasonable for the jury to infer that a man of that size would not have gotten so incredibly intoxicated between the time that the vehicle crashed and the time he was found, especially based on testimony. I believe one trooper said it was the bottle was half empty. Another trooper, I believe, testified it was about 3/4 full. So it would have been reasonable for the jury to infer that he would have been intoxicated before that, and that he was likely not intoxicated based on drinking 1 or 2 glasses of wine in the backyard where he was found unconscious. So I think that evidence is reasonable to infer that he was the operator of the vehicle. And I can certainly address any other questions from your honors about the issue of the letters or the issue of the closing argument. I would just say in terms of the closing argument, it was a fair reply from what defense counsel argued in his own closing. Essentially, the argument was the defendant was a passenger. Whoever was a driver would have sustained bumps, bruises, or other types of injuries. You had testimony that there was no blood found in the car. There were no broken windows in the car. So it was basically a fair, and of course that, I think the prosecutor was essentially asking the jurors to use their common sense. Do you think that the airbag would have gone off had someone been in the car? And again, there was no evidence there were 2 people in that car based on the evidence of 1 set of footprints in the snow, the dog only tracking a very, very strong pull on the track, which ultimately led to the defendant.
And you don't think it requires expert evidence on the question of whether the failure of the passenger side airbag to deploy is because there was no one in the passenger seat versus for some other reason, like the nature of the impact to the car?
I don't believe the defendant cited any cases which require expert testimony with airbag deployment. I'm not saying that, I'm not aware of any, but I'm saying none was cited to. And I believe that the cases that were cited to involved, there was a products liability case where an expert was required to testify about a design defect. And I believe the other case, which was a criminal case, dealt with, I believe it's the EDR device, which does have some information on airbag deployment as well as speed, but no cases specifically about airbag deployment. And if there are no further questions, Your Honor, I'd be glad to rest on my brief.
Hearing none, thank you both. Very well argued on both sides. Thank you very much.
Yeah, please the court. My name is Matthew Zandrowski and I represent the defendant, Jose Barros. Mr. Barros's issue on appeal concerns whether the trial court erroneously allowed the only eyewitness to the crime to identify him for the first time in court without any previous identification procedures. I view this case as a Creighton issue. And so in this case, Mr. Lincoln had only observed Mr. Barros for 20 to 30 seconds on the night of the incident. He had no prior familiarity with Mr. Burrows. He wasn't an arresting officer. And so he should have had, for his identification to be admissible in court, he should have had an out-of-court identification procedure, and there wasn't. And so I argue that it was error for the trial judge to consider the Mr. Lincoln's identification at that bench trial.
So there's some, it's permitted to identify him for the first time if there's a good reason for that. Would you agree with that, Attorney Zandrowski?
Yes.
Okay. And would you agree also that although he may have only observed him for 20 to 30 seconds, he actually spoke to him during that period of time and they had some conversation?
Yes, he did.
Okay. And there's some evidence that the defendant actually admitted being in a car that one could infer was the car that was belonged to the victim in this matter. Is that fair to say?
Yeah, it is fair to say, yes.
So where he doesn't contest that he was actually in the car, what's the harm in identifying him for the first time in the courtroom?
I would say that in this case that Mr. Lincoln was as the only eyewitness to the crime, and given Mr. Barros' his testimony was, well, we could infer he was in the car. It was also not particularly firm testimony. He stated he didn't know where he was a few different times. He was only adopting when the officer had told him where he was on Foster Street. And so in this case, as the only eyewitness, it would be prejudicial, or it wasn't a good reason to not have Mr. Lincoln do a previous identification procedure.
And this was a jury waived trial, right?
Yes, it was. So this error prejudiced Mr. Barros because, as I said, Mr. Lincoln was the only eyewitness. We know that on the record, the judge took Mr. Lincoln's identification into account when finding Mr. Barros guilty. He said it at page 86 that based on the representations made by Mr. Barros and Mr. Lincoln and the police officer that Mr. Barros was in the car that night. So we know that the trial judge credited and took that identification into account in determining the case. Mr. Barros didn't identify, he testified, but he didn't identify the car. His identification, as I said, or his testimony was mixed. It wasn't particularly firm. He didn't know where he was. He testified. And so all those combined, in this case, I argue, formed a prejudicial error for the trial judge to consider the identification.
Would you agree that the victim and the defendant essentially testified to having the same conversation on the night of the incident while in the car?
I would agree to that, yes. If there are no further questions, I would rest on my brief.
Hearing none. Thank you very much.
Thank you.
Good morning, Your Honors. Patrick Nevins for the Commonwealth. I think it's good afternoon. I think it's important to start with the fact that regardless of getting into the Creighton issue, it's important to note that error or no error, there was no prejudice in admitting the in-court testimony. This was certainly a case where the judge, who was the sole fact finder, and who's presumed not to be inappropriately influenced, the error did not influence the jury, or in this case, the judge. And if it did, it had but very slight effect. I think it's important to note that the victim's in-court identification did not substantively add anything to the Commonwealth's evidence that the defendant was in the car. The defendant himself repeatedly on direct and cross-examination admitted that he was in the car. You also have the officer's testimony as well. The defendant would have gained nothing had the trial judge decided to exclude the in-court testimony as opposed to admitting it. Furthermore, the defendant's identity was not an issue at trial. As this court has said in Peruzzi, where they were deciding on the issue of the malice instruction. And that in that case, the malice instruction did hit at the heart of what the jury was trying to determine. In that case was it malice or was it wanton? And that was to determine what type of crime to find the defendant guilty of. Here, that's not the case. The defendant's identity was not the issue that the trier of fact was trying to determine.
But the reason it wasn't an issue, if I understand you correctly, is because there was so much other evidence that it was the defendant in the car. Not that it didn't have to be proven, but you're essentially making a no prejudice argument, aren't you?
Yes, Your Honor. And so, therefore, in the defendant's closing argument, defense counsel really focused in on that the issue here was whether the defendant committed the break-in and entering with an intent, with a felonious intent, or with an intent to commit a misdemeanor. The defendant basically conceded the fact that he was in the car and that identity was not an issue here. But going back onto the first issue in addressing Creighton, the trial judge did not abuse his discretion by allowing the victim to make the in-court identification, because this was consistent with Creighton and the notion that there may be good reason, particularly when the identification is merely confirmatory and not material to determining guilt. And so in Creighton, the court lists, it's not an exhaustive list, but they talk about familiarity with the defendant beforehand, or if the eyewitness was also the arresting officer, and that the court makes a statement that in both of these circumstances, it's understood by the jury as a confirmation that the defendant sitting in the courtroom is the same person whose conduct is at issue. And they even use the language, for instance, there may be good reason, and they list arresting officer, person familiar. So it's not saying that those are the only two reasons. But the heart of that is the idea of a confirmatory identification, because there's little risk of misidentification, which is the whole point of Creighton to begin with, is lessening any unfairness of an in-court identification. And here, where it's not, the in-court identification is not material to determining guilt, and is essentially just to merely inform the jury, or in this case, the judge. It should be allowed because it does not strike as unfair in these circumstances. Any sense of unfairness has been diminished.
When you say it's not material, do you mean that it wasn't relevant, or that it was simply cumulative and didn't have any kind of tangible impact on the finding because there was so much other evidence of identity?
That it was cumulative, and that's what this court had talked about in Stewart. And this case is a little bit different than Stewart in that the victim did not stay with the defendant until the police arrived. But it's that idea of it's a confirmation. And here, any unfairness has been minimized. And similar to in Stewart, where the witnesses were testifying as to confirm that the defendant sitting in the courtroom was the same person, here it's the same issue, particularly where identity.
If you didn't have the officer's testimony about what the defendant had said, and if you didn't have the defendant himself testifying and admitting he was in the car, then wouldn't this in-court identification be highly material?
Yes, in that circumstance, yes, Your Honor. But this case is different in the fact that identity is not an issue because the defendant concedes it, and there's also the officer's testimony. There's, in terms of whether the victim was familiarized himself with the defendant, Commonwealth would argue that a face-to-face interaction, but for 30 seconds, but a face-to-face interaction, and the victim says that he goes back and he has the Ring doorbell surveillance camera, that he watches the surveillance and gives it over to the police. Again, that could be enough where the victim became familiar enough with the defendant to make the in-court identification.
But the victim didn't say, did he, that in looking at the videotape from the doorbell, he could see the defendant's face? And so that once he saw the defendant in court, he could say, yeah, I recognize him. He's the guy who I could see on the tape.
Correct. He did not say that, Your Honor.
All right. For all we know, he was just a shadowy figure getting into the car. And that's what caused the victim to go out and investigate, but he couldn't see the defendant's facial features.
Correct.
And this was at night. And
well, when the victim does testify that when he interacted with the defendant in his driveway, in the driver's seat, that it was light in his driveway despite it being rainy and at dark. But in terms of the video surveillance, the victim did not elaborate as to what the visibility was on the camera.
Doesn't the defense counsel concede that there's no question that he was in the car? What weight should we give that, given the identification had already been made in court?
I think a significant amount of weight in both the fact that when dealing with the first issue, whether this raises a Creighton issue and whether the evidence should have been excluded, the fact that identity was not an issue lends itself even more to that this should be allowed in as a confirmation, as a confirmatory testimony that the defendant in the courtroom is the same person. Even beyond Creighton, when we talk about error or no error, was there prejudice? Even if there was error, there's still no prejudice because, as you said, Your Honor, defense counsel concedes that identity is not an issue. If the court has no further questions, the Commonwealth rests on its brief.
I think we understand the two positions. Thank you very much.
Thank you.
Good morning, Your Honors. Theodore Barone on behalf of the plaintiff in this particular case.
Good morning, Attorney Barone. Just one moment so I can just get on the record. This is the fourth matter on our list. It is Donald Zani. Is that how you pronounce his name? Zani?
Yes, Your Honor.
Versus the Town of Ashland Conservation Commission, docket 19P1409. Attorney Barone, excuse me for interrupting.
Oh, thank you very much, Your Honor. Good morning, Your Honors. Thank you for having us virtually in these uncertain times. My client, Donald Zani, trustee, filed an amended complaint 2016, an 8-count complaint against the Town of Ashland in October of 2017. There was a motion for judgment on the pleadings by the town, and I believe my recollection is 3 counts were dismissed, leaving either 4 or 5 counts.
Mr. Barone?
Yes, Your Honor.
I think we probably have the facts down pretty well. I have a specific question.
Very well.
Which is that, putting aside anything that counsel said at the November 7th hearing on the motion to withdraw and the motion to enforce a settlement agreement, and looking just at the email exchanges from the summer, where was it communicated that a meeting between your client and the Conservation Commission was a material term of the settlement that was being discussed, such that if there wasn't agreement on that, there wasn't a settlement? It seemed to me that the August 17th email that your predecessor counsel sent to defense counsel said the plaintiff will dismiss the complaint if the fine is reduced to $300. And then he says, let's request a 60-day NISI order during which time this meeting can occur. But proposing the 60-day NISI order suggests, okay, we've got a settlement. It's just a matter of 60 days to get the paperwork straight. Not, we still need to agree on a material term. So sorry for the long-winded question, but there it is.
No problem, Your Honor. Thank you. I would turn the court's attention the record appendix pages 122 and 123, which denotes email exchange between Attorney Cloherty and Attorney Avery, who was Mr. Zani's attorney at that particular time. The discussion with respect to a pre-settlement, if you will, a pre-settlement inspection of the property in terms of having Mr. Zani understand what his actual obligations would be as a practical matter on the order of conditions was discussed. Mr. Avery indicated that it was the offer of settlement was strictly a cost-benefit decision, and this is on page 122 of the record appendix. It is an August 30, 2018 at 6:34 p.m. Email from Avery to Cloherty, and it indicates offer of settlement strictly a cost-benefit decision, one that is dependent upon having the most information possible concerning the anticipated scope, cost of remaining work required under the conditions. Hence, I suggested to you on August 17 via email, no dismissal should be filed prior to pre-construction meeting. You authorized me to contact Ms. Dos Anjos to schedule the same, and that she will not do so until there is a signed dismissal and release.
Right, but Mr. Barone, the very next sentence of that email says, I don't understand the need for taking such a hard line when we've already reached a successful compromise on material terms. That suggests to me that the meeting to agree on what work was still required under the order of conditions was not a material term.
Well, except that the proposed settlement agreement indicates, and it was drafted by Attorney Cloherty, indicated that the order of conditions, successful completion and requirement of the order of conditions was part of that settlement agreement. There was certainly discussion by Attorney Avery that in this email that, before his client was willing to settle, and he had to review the settlement documents, there's a subsequent discussion that this pre-construction meeting had to take place because it was a cost-benefit analysis. I would suggest that what Attorney Avery is saying there is we are close. We are close, but my client needs to see exactly what he's going to have to do before he's willing to get out of this litigation and end this litigation. So I would suggest that Attorney Avery's language is somewhat ambiguous, but that it also is quite clear that Donald Zani really needs that meeting before he's ready to settle.
Counsel, let's assume it's arguable whether the parties agreed on all material terms. Let's just assume that. We're here on an appeal from a denial of a Rule 60 motion, right?
Yes.
So that Rule 60 is not a vehicle to re-argue the merits of a decision. It has to fit within the parameters of one of the subsections of Rule 60. So which part of Rule 60 are you relying on? Is it just excusable neglect?
It is, well, yes, that's one of them, but also extraordinary circumstances. As I read I'm sorry, you were about to say?
All right, so putting aside the Rule 60d6, on excusable neglect, that would only be a basis for relief, I think, if the grounds for the judge's decision to allow the motion to enforce the settlement agreement was based on your client's absence from the hearing. And I know that's mentioned in her order, but she also could have allowed the motion on the merits, finding that in fact, yes, there was an enforceable settlement agreement. So how is excusable neglect relevant here?
I would have to respectfully disagree, Your Honor, that the transcript is very clear with respect to the judge, and the judge's indication is also very clear that Mr. Zani wasn't there. He'd been given appropriate notice, and so that the motion to enforce the settlement agreement was allowed. At the same time, Mr. Zani's then attorney was getting out of the case. Mr. Zani's then attorney, Mr. Avery, filed the motion to withdraw, indicated he did not have authority with respect to assent to the motion to withdraw or not, and then was asked by the judge well, have you had substantive discussions? He does say yes. He says, but he's got no authority with respect to assenting to that motion. Then, when he subsequent to that, he then makes a statement, even though he's not authorized to make a statement, that he believes that the material terms.
So it's your view that the judge didn't consider the merits of the question at all?
It would not appear that way, and it's very difficult to tell because there were no written findings of fact, and the only thing that's on the side notes is that my client didn't show up. Shortly thereafter, right. I filed my motion.
Let's say that excusable neglect is relevant. You represent that your client knew of the hearing by sometime in mid-November. Yet correct. The Rule 60 motion was not filed until March. There was an affidavit saying that, he was certainly aware of the case. I know he was having some serious medical issues, but essentially he's saying that he wasn't checking his mail, even though he was aware of the case. And then it takes him another, 3+ months to actually file the motion. So why would it be an abuse of a discretion for the judge to deny Rule 60B motion in those circumstances?
Because he was 84 years old. He was very, very sick. You can see from the medical records that were attached to his affidavit that there was, he had a lot of confusion. He hired me at best in a timely fashion as best he could, and I immediately filed the motion with his affidavit that talks at great length about his medical conditions. The medical records are attached to he went into the hospital during the time of these negotiations. He went into the hospital between August 12th and August 29th. That's at record of 2018. That's at record appendix 147. Then he went back into the hospital in October of 2018, just before the motion. It's October 15th through October 29th. All right, so then he finds out about this motion. He's still 84 years old. He's still sick. He's still in a difficult state. I would suggest to Your Honor that it simply took him some time to make a determination as to what to do and hire counsel to do it. As soon as I was hired, relatively soon after, put the paperwork together, and I started representing him and putting in the motion. So I would suggest to you that he acted timely, and I would also suggest, with respect to the excusable neglect elements, that they cut in his favor. He acted promptly after entry of the order. I would suggest, given his age, whether there's a showing by way of affidavit that the claim sought to be revised as merit. I would respectfully suggest that email trail indicates that there's uncertainty as to the merits, despite Mr. Avery's opinion at the hearing, and further indicating that the town cited a case, Lewis versus Sumner. It's an oldie but goodie, 1847 case. It says an attorney can find a client until he's out or until the party revokes. He was out, Avery was, if you will. He was out sometime before November 7th. He filed the motion, I believe, in October of 2018. He files the motion. My client is not there on November 7th. Attorney Avery then shows up, says he's got no authority to assent to the town of Ashland's motion, says that he and his client are essentially at an impasse, at a disagreement, and then despite having no authority, he makes a statement which is in the record. I can't put my hand on it at this moment, but he makes a statement in the record where he indicates that and you take no position on that, which is the settlement motion. Mr. Avery says, no, Your Honor. The settlement agreement reflects the material terms that were initially agreed upon by my client. I would suggest to Your Honor, he had no authority at that particular point. He was moving to withdraw, and he's in there. Still, before the withdrawal is allowed, he's got to act in the best interest of his client. I would respectfully suggest to you that he became an adverse witness at that particular moment. Subsequent to that, my client then files his affidavit and says, I never agreed to settle this case. I never agreed to settle this case. So you've got a factual dispute potentially between an adverse witness, who is Attorney Avery, and my client.
I see your client's affidavit saying I never wanted to settle on those, without some agreement on what work remained to be done. But where does your client say, I communicated to my attorney at the time he was negotiating the settlement agreement that this was a material term? Because if it was in your client's head, but he didn't tell his predecessor attorney, then I don't see how it's relevant.
Well, number one, I would suggest to you, Your Honor, thank you for the question. I would suggest to you that Attorney Avery, by walking in there, by filing the motion to withdraw, and by walking in there looking to withdraw, indicating that he was in disagreement, is a very strong inference that there had been discussion, disagreement.
By November 7th, and even by very late August, perhaps, or early September, it's clear that prior counsel has been informed that this is something that's at least important somehow to your client. But my question is, during the time that the settlement was being negotiated, the earlier set of emails that ends up on
August emails?
Yeah, the August emails where the August 20th from Ryan Avery to John Clarity. Thank you, John, for being willing to draft up the agreement. At that point, what evidence is there that your client had told prior counsel, this is a material term to me. I need a meeting with the CONCOM about what work remains before I can agree to settle?
I would respectfully suggest to you that Avery's follow-up email on the 30th would make that suggestion. And number two, my client was in the hospital during that time. He was in the hospital from August 12th, and the medical records are attached to his affidavit, from August 12th through substantially the remainder of the month, August 29th, and then went back to the hospital in October when all the motion practice by Judge Avery. So I would respectfully suggest to you that the strong inferences, there may not be any specific statement from my client. There may not be any specific indication from Avery other than he says, my client says he wants to know what's going on with respect to the order of conditions practically before. And then you put on top of that, my client's in the hospital during these negotiations as an 84-year-old man. I think the inferences are strong and clear that he had made his objection, if you will, to not settling prior to understanding what the practical terms were.
I have one other question for you. Given that Mr. Zani's been under an obligation for some time to comply with the order of conditions, whatever it may mean, and given that, at least as things currently stand, although the appeal is pending, he's under an order to comply with it. Has there been any thought given, and I'm not really asking you to answer, to just sitting down with the town now and saying, okay, what really remains to be done here? Because the theme that runs throughout a lot of these papers is it's more expensive to litigate this than it necessarily is to do the work if we can just agree on what the work is. So,
Your Honor, I am always open as a litigator and as a representative of clients to discussing with opposing counsel those kinds of possibilities that do not necessitate litigation. But I would also suggest that, and I know that the town makes the point in their brief, I believe, that the order of conditions had to be satisfied no matter what. I would respectfully suggest to your honors that it's well settled that abandonment of a claim is believed to be well founded, and the claim was still outstanding at least before November 7th or thereabouts. Surrender of a thing of value and sufficient consideration. So before he was going to surrender that, he needed to know exactly what he was going to be required to do under the order of conditions. So to answer your questions, I'm always open for those kinds of discussions, Your Honor. I'm sorry, was there another question? Did I cut somebody off?
I see that's your time, but I do have just one other question.
Sure.
I'm looking at the August 17th email where it looks like it's to Mr. Clarity, and your client or the letter represents that why don't we have an additional 60 days so that Don's engineer can meet with the conservation agent and or CONCOM to make sure that they are on the same page. But that doesn't have anything to do with the material terms of the agreement with Mr. Clardy's client, does it?
Yes, I would suggest that it does, given the subsequent discussions and emails between Attorney Clardy and Attorney Avery during that period of time, the middle of August through the end of August. That's the important point. That's the nub of the disagreement right there. At some particular point in time, there was a disagreement as to that cost-benefit analysis that my client was going through, and he wasn't ready to settle this particular dispute. So yes, on August 17th, it's mentioned. And by the way, my client's in the hospital at that time. My client's in the hospital when that is being written. So I would respectfully suggest to you that given the entire situation, the emails between August 29 and August 30, as well as my client's medical condition, as well as the inferences that can be drawn from Attorney Avery's withdrawal from the case as having a disagreement with his client, that Attorney Avery's opinion, I would respectfully suggest, is not really what's relevant. And he, at some point, certainly, Mr. Zani indicates that he never made such agreement. So without having the opportunity to be heard, Your Honor, in a court, as opposed to getting the decision back that says, basically, we agree with everything, for all the reasons stated in Clardy's documents, this is why I'm doing it, as well as that's in response to my motion. In response to the original motion, it just says because Zani's not there.
I think we understand. I see that's your time. Thank you very much, Attorney Brown.
Thank you very much, Your Honors, all of you. Thank you. I appreciated the questions.
Attorney Clardy.
Thank you, Your Honor. May it please the court, I'm John Clardy. I represent the town of Ashland and the Ashland Conservation Commission members that are named in this lawsuit. We view this as a fairly straightforward case. It was an exchange of emails on the eve of the closure of discovery, wherein the parties agreed to settle the case. And there were three terms to settle the case. One, reduce the fines to $300. Two, this was plaintiff's statement, mind you. Plaintiff said, we will fulfill the conditions of the order of conditions. And three, we wanted $20,000 in attorney's fees. So we pushed back as the defendants and said, no, we're not going to pay attorney's fees, but we'll agree to the other two conditions. And the plaintiff's response, as indicated in August 7th email, was, we're willing to dismiss for reducing the fines. That's essentially the settlement right there, because they already knew they had to fulfill the order of conditions, right? By way of background, this order of conditions was issued in January of 2016, some 2.5 years before the settlement was taking place. And it was issued because the plaintiff's abutters reported him clear-cutting land on wetlands. His property was commercial property, it bordered wetlands, and he had a landscaping company piling logs there. He clear-cutted trees and put wood chips throughout the conservation area. And he had a tow truck company that was parking vehicles there in the protected area. There was a total, his plaintiff's own engineers said there was a total of 12,000 square feet of impacted wetlands that were affected.
So we understand that the order of conditions issued, and he didn't seek certiorari review of it within the 60-day period.
Right.
But wasn't his lawsuit directed, at least in part, at the manner in which the town was going about enforcing the order? So wasn't the question of what was required for compliance at issue in the lawsuit? Wasn't that a matter of dispute in the lawsuit?
Yes, Your Honor. I guess that's the way we kind of perceived it. We did file a motion to dismiss and a motion for judgment on the pleadings, asserting grounds that it was untimely, that he waived his rights by not bringing a claim within 60 days. However, there were essentially kind of retaliatory arguments that he was being, the enforcement actions were retaliatory. There was a breach of contract based on the existence of a 2003 easement. So there were other non-order of conditions claims in the complaint, certainly. But the crux of the issue was whether he's complying with the Wetlands Act and how do we enforce that? And we try to resolve this. Inspections are done as part of a regular routine practice of conservation commissions. That was not a material term. What's at issue here is essentially the timing of the inspection, not whether inspections can take place, but the timing of them. And after agreeing to settlement,
yes. Can I ask you a slightly different question? Isn't it fair to read the judge's comments at the hearing and her in her order allowing the motion to enforce that her decision was based on the plaintiff's failure to appear at the hearing? Isn't that a fair reading of what she decided?
No, Your Honor, I don't believe so. I mean, I saw it as a ruling on the merits as well, not merely on its status as an unopposed motion. Certainly courts can allow motions as unopposed without any further inquiry. But I think as the hearing transcript revealed, the judge wasn't just looking at, whether this motion was quote unquote unopposed because the plaintiff failed to appear, but also whether there was a genuine settlement that took place. And there's evidence of.
It seems to me there was much discussion about that issue other than Attorney Avery, who was seeking to withdraw, making a representation that he believed that there was a settlement. And it seems to me there's a procedural issue here where the order itself specifically mentions the plaintiff's failure to appear. And I think you can infer that perhaps she relied on Attorney Avery's representations in allowing the motion. So if that's a fair reading, aren't we in excusable neglect land? And so if the plaintiff can show excusable neglect, then the motion should have been allowed.
No, Your Honor, for two reasons. One, it doesn't rise to the level of excusable neglect, and I can address that a little more. But two, the judge's decision regarding the reliance on Attorney Avery's representations, Attorney Avery was basically confirming that there was an agreement as evidenced by the documents. I mean, we can't, the fact that the attorney who still entered, the judge could have denied the motion to withdraw. I've had cases where judges have denied motions to withdraw by counsel.
But Avery expressly said at the hearing that he didn't have authorization to take a position on the motion to enforce.
Right.
And then he takes a position in essence.
No, what he did was he basically was truthful to the court by stating and recognizing that there was this dialogue and there was a meeting of the minds.
Right, I understand that. I mean, I'm not saying he did anything wrong. I'm just saying that it seems to me then it's problematic for the judge to have relied on his representation. And then to note that, and the plaintiff did not appear at this hearing to basically counter what Attorney Avery was saying.
Yeah, Judge, I think this is, again, this happens when attorneys go to withdraw, right? Attorneys withdraw not infrequently in court, and they make representations that there's a breakdown in the relationship.
I agree, but let's say that plaintiff had showed up at the hearing and said, okay, my attorney and I are not agreeing on how to go forward on this case, so I'd like to hire a new attorney to take a position on this, to put forward my position on this motion to enforce. In that situation, could the judge just have relied on Avery's representation? Which is why I think that the plaintiff's absence at the hearing is actually relevant to the judge's decision.
Well, I think to a certain extent, what happened thereafter kind of mitigates any relevance to that, because they did have a second hearing. Attorney Burrows did appear. He went before two judges and was referred to Judge Howe to reconsider it, and Judge Howe elected not to hold the hearing. There's no obligation, as far as I can see, under the rules of procedure that mandates a hearing. She felt comfortable in her decision. She may not have articulated it on the merits, but this court can look at the merits as well. So for his complaint, essentially, is that we should have looked at the merits. Well, we're asking the court then to look at the merits if that's the issue. Then this court, the appeals court, can look at the email correspondence, make a determination that there was, in fact, an agreement as to the material terms. It was sufficiently definite, and therefore it's enforceable. So,
and can we make that determination without considering anything that was said at the November 7th hearing? And can we make it, this is a two-part question, can we make it even taking into account what the plaintiff says in his later filed affidavit?
Yes, Judge, that's our position. Our position is the history of the emails speak for themselves, and there was essentially an agreement as of that August 17, 2018 email. By that email chain and that trail of communications, the two elements were met. The terms were sufficiently complete and definite, and there was a present intention of the parties to be bound. Notably, if you look at plaintiff's affidavit, there's things that he doesn't say which are important. He never disputes Avery's representation that I spoke by phone and in person with Mr. Zani about the motion to enforce settlement coming forward and my need to withdraw. That's not denied by Mr. Zani. It's funny, I think the court pointed it out earlier, that there's this representation that I never would have made this deal had I known. Again, the affidavit is silent as to him communicating that to his attorney. So the attorney states without dispute that he spoke to his client about the settlement, had an agreement. We have the date of August 17th where it's memorialized in a writing, and there's nothing here to undercut that. So I think there's plenty of evidence that this court can affirm the enforcement of the settlement, even without looking at Attorney Avery's statements during that hearing.
I had a procedural question. The plaintiff has argued, and you have argued, that this matter is governed to some extent by Rule 60B. As I understand it, no judgment entered until April 3rd of 2019. That was by Judge Henry, after Judge Howe had looked at Mr. Burrows' motion and the plaintiff's affidavit and stuck to her prior decision. So is this, I mean, that motion was not seeking to disturb a prior judgment. So I'm not quite sure how 60B comes into it.
I don't think 60B applies either procedurally, Judge. But, you know, here we
are.
So
the standards, in other words, would you agree that the standards of 60B, excusable neglect, for example, do not have to be met here? I mean, the judge could have, does the plaintiff have to show excusable neglect here to obtain relief?
No, I don't think he has to show it, and I don't think he has shown it anyway. I think this is an abuse of discretion review on a clearly erroneous standard for the enforcement for the order enforcing settlement. I don't really see this as a relief from judgment case, and I don't think it fits within the four corners of that anyway. I don't think they've shown an excusable neglect by Attorney Avery, and the only excusable neglect that they've pointed to is that my client didn't attend the hearing. Well, there's no obligation for a plaintiff to attend a hearing under Rule 9C. And in fact, the court didn't order that the plaintiff attend the hearing. So I don't think that rises to the level of excusable neglect. I think what he's trying to argue is my own client's refusal to read his mail was excusable neglect. If that's the argument, surely a deliberate refusal to read your own mail from your attorney does not rise to the level of excusable neglect under the case law interpreting that term.
Make sure I understand your position. You're saying that the plaintiff does not need to fit his motion within the parameters of Rule 60?
Well, I guess, Judge, maybe I misspoke to the extent that that's the only way we're here. Essentially, he's appealing from a judgment. The judgment had not entered upon the motion to enforce a settlement order. I suppose he could have taken an interlocutory single justice appeal from that enforcement order of the settlement. But what ended up happening procedurally is Judge Henry decided there's no to dispute here. I'm going to enter judgment and then give you your right to appeal. So I'm not going to penalize the plaintiff for going before the trial judge and the trial judge saying, this is your mechanism for appeal. Here, I'm going to enter judgment on the enforcement order and then you have to appeal that way. So whether he has to get bootstrapped into an excusable neglect standard or relief from judgment, I suppose that's his only vehicle of reviewing it. But I think it's not really an excusable neglect standard. It's an abuse of discretion standard by the judge in enforcing the settlement. Otherwise, all he'd get would be another hearing on the motion to enforce settlement. And I don't think that's what he wants. I think he wants a ruling from this court that the settlement was not enforced.
That is what he wants. I think that is what he wants, is he wants the opportunity to go back with his new attorney and oppose the motion to enforce.
Well, certainly then we'll probably back up here, Judge, on another appeal because and we're convinced that there is an enforceable settlement agreement here. So I think that would be a remedy without any real relief.
So how does, let's look at what the substance of what the plaintiff says in his affidavit about the the terms of settlement, and I'm just looking for it here. It's on page 145 of the record appendix. He has a few paragraphs there. My position had been all along that I wouldn't agree to settle unless the conservation agent came to the disputed property and we could talk about what had to be done. Can we, taking into account what the plaintiff says in his affidavit there, can we still find that there's an enforceable settlement?
Yes, Your Honor. I mean, I think as you pointed out in your question to Attorney Barone, that there's no affidavit stating I told my attorney these were the limits. So what we have essentially is an affidavit of my subjective unvoiced intent all along, or this is what I thought all along. In contrast, we have Attorney Avery's email correspondence saying repeatedly, I've talked to my client, this is what my client will do. And then on August 17th, my client will agree to dismiss for reduction of the fines to $300. And nowhere does Mr. Zani's affidavit dispute that. His affidavit does not say, I never told my attorney he could settle for reduction of the fines to $300. So it's just all about post hoc, I think, morning after regret about the settlement, once he started having to realize that he's going to have to fix his property consistent with the order of conditions. So we've made other arguments in our briefs concerning other legal grounds, and unless there's further questions from the court, I see my time is running out, and so we'll rest on our papers.
Thank you very much. Thank you both. Very good arguments. We appreciate it. Thank you. This is the fifth matter on our list, Wells Fargo Bank versus Ronald, Maundy, and others, docket 19P1342. Counsel.
If it may please the court. Attorney Luke McCardle on behalf of the appellant, Ronald Maundy. We're here on a limited issue regarding the statutory and jurisdictional appellate period pursuant to 239, section 5. Just a brief recitation on the facts that are relevant to the matter. This was a summary.
I think we're well familiar with the facts.
Okay, yeah, we know the facts, so dive right into it.
All right, great. So the summary judgment hearing was in November of 2018. The decision wasn't made for 5 months until April of 2019. So it kind of, the intended summary process wasn't really, it wasn't an expedited process. This was a post-foreclosure matter. So they're typically, they go down a different path as far as the timing.
Right. I understand I see the affidavit saying that your office didn't receive notice of the decision and order. One thing that I thought was kind of conspicuously absent from that affidavit, as pointed out in a footnote in the bank's brief, is the affidavit doesn't say we didn't receive the judgment. And it's really the judgment that triggers the time for appeal. So could you address that?
I agree. I noticed that in reviewing my brief that there was definitely some things missing. I'll fully acknowledge that, and that's why I'm hopefully clarify the record here. If you take a look at the appendix, and we go to the decision and the order, which is at page 27 of the appendix, page 32 of the appendix, which is the last page, shows the notice that was given. It always CCs the attorneys who are sent the notice. And it shows specifically that it was only the attorneys for the plaintiffs. You then go to the judgment, which is at page 33 of the appendix, and page 34 shows the service to the attorneys, which again, service was only made on the plaintiffs. So it's within the record that demonstrates that the notice of the judgment and the decision of order was mistakenly only sent to the plaintiff.
Is this common practice in the housing court to CC counsel on an order or a judgment?
That's how they, that's how they acknowledge who notice is sent to within the record. So it makes it clear that notice was not sent at all to our office. And I know this is hearsay, but I did confirm that with the clerk's office there on what the issue was. And looking further at the docket itself, which is at the appendix pages 3 to 5, it clearly shows the listed attorneys, myself, Attorney McGuire, and my father, Attorney McCardle, all listed for both defendants, Ronald and Allison Maundy. So the fact that we didn't get any notice of this is concerning. And this has never been a problem. I practice in the housing court on a regular basis. I've never had this problem. This is the first time. And when you're waiting 5 months for a decision, having to check the docket with a 10-day window is a lot to ask, I would suggest.
So this is a statutory period for the notice of appeal, 10 days. It's not set by court rule. So given that, what court rule authorizes the judge to extend the notice of appeal period?
I would suggest that any procedural rule or law has to take into consideration extraordinary circumstances such as this, just as in the case that I have cited, the Schaff case, which is the only case cited by either party that actually has facts that are relatively similar in a summary process action, where notice was only sent to the prior counsel, not the then current counsel, so we had no idea of the judgment being entered. And the judge used her discretion to re-enter and allow the party to properly appeal. So I think the facts of that case are on point, if any, with all the cases that are cited by the plaintiff. They just cite the rule in passing. They're not even part of the holdings in any of those cases if you actually read the facts of those cases. But more importantly, I really want to point you to a case law that I didn't stumble upon until after I submitted my brief, which comes down from the Supreme Court of the United States, which is Hill versus Hawes. It's 320 U.S. 520. This case, for me, I think it shuts the door or opens the door and gives you clarity on my argument. It specifically is a tailored decision to Rule 77D, where it says that the clerk of the court shall immediately send notice to the parties of record or their counsel. This is a rule of the court. The U.S. Supreme Court says it is true that Rule 77D does not purport to attach any consequences to the failure of the clerk to give the prescribed notice, but we think of no reason for requiring the notice if counsel in the case are not entitled to rely upon the requirement that it be given.
But that's the federal rule that the Supreme Court's interpreting.
Right, but it mirrors our rule.
Well, I'm not so sure. 77D of at least the Rules of Civil Procedure says lack of notice of the entry by the clerk does not affect the time to appeal.
Correct.
Or relieve or authorize the court to relieve a party for failure to appeal within the time allowed. So unlike the federal rule, our rule, for better or worse, does explicitly say, even if the clerk didn't give notice, that doesn't by itself authorize the court to extend the time for appeal. So how do we get around that?
No, I think that the court in this case, the U.S. Supreme Court, addresses that direct issue in their holding. It basically says, nevertheless, even though the court isn't, you're not supposed to be relieved from the statutory period to appeal, it makes no literal sense in interpretation of that rule to allow an attorney to, depend on that rule and then not allow a late notice of appeal. It goes on to say what should be done in these situations is that the court should correct it, send it pursuant to the rule with immediate notice to the parties, re-enter the judgment according to Rule 77, and allow the period to then start over so that the appeal can properly be made. It's pretty clear in that in the Supreme Court case, and then there's another case.
So wait a sec. So you're saying Hill suggests that the court could vacate the judgment and then re-enter it in order to create a new appeal period?
Yes.
Did you try to do that in this case?
No, I mean, we're here now. I didn't try to do that in this case. But it was the issue presented to the court was basically the same procedural course as this case. It was appealed.
Well, if that safety valve exists where you could if you could demonstrate to the trial court that you didn't get notice of the judgment, and the trial court believed that representation, found that there was no prejudice to the defendants, to the plaintiff in this case, that you'd acted promptly. If the trial court had the discretion to vacate the judgment and then re-enter it in order to create a new appeal period, would that avoid the constitutional problem that you're pointing to?
Absolutely. I believe
so. So if that's true, are you properly before us today in that you have not exhausted your remedies?
I think, I mean, if that's an alternative remedy, that's not the procedural course that these cases that I've just cited went. The court was allowed to provide the remedy itself. So I do acknowledge that is a possible further avenue. But I would suggest that this course would be the proper course to take. At this time.
Regarding your constitutional claim, did you actually raise that in the housing court?
As far as asking them to,
in essence, did you say to the judge, and I didn't see it in the papers, but you could have said it orally, look, if we don't have a chance to appeal this judgment of which we never got timely notice, then that's a constitutional problem. So judge, one way or another, you have to find a way to let us appeal. Did you?
To be honest with you, I don't want to, say something on the record that I don't remember exactly if that was raised in front of the hearing judge at the time. We were kind of scrambling to, try and navigate through that mess of not getting notice and just all of a sudden, having an execution on my client with, no opportunity. I actually want to point you just to point you guys to another case, just so you have it on record, because I didn't cite it. It's Commercial Credit Corp versus U.S., which is 175 F2D 905, which also cites the U.S. Supreme Court case, and also states that we think it was warranted, assuming the clerk would perform his duty and serve notice of entry of judgment or order in this case as provided by Rule 77. In this view of the situation, claimant was deprived of his statutory right of appeal without any fault or neglect. And I think that's important because, we could argue the excusable neglect, but there really was no excusable neglect when notice isn't provided pursuant to a court rule. So I think, in these extraordinary circumstances, it's very difficult to ask an attorney to be clairvoyant, I guess, in some degree, or make a daily docket checks on a housing court docket when the hearing was 5 months, previously, and a dozen of clients in these same situations that I'm, trying to help on a daily basis. It's, puts me into a precarious situation as far as liability, myself. So it just doesn't. It seems like the jurisdictional aspect of this rule. There needs to be some extraordinary circumstance where discretion can come into play. I don't think it would make sense otherwise.
Well, you may want to look at a case called Abbott versus John Hancock Mutual Life. It's 18 Mass Appeals Court 508, which seems to recognize this mechanism that you referred to earlier. At the state level about moving to vacate a judgment and then re-enter it to create a new appeal period. So, if that safety valve does exist in the state system as it seems to, and there's a case called Chavour versus Lewis, 383 Mass 801, that basically says the 1 year time limit does not apply to such motions. If that safety valve exists, I'm having a hard time seeing the procedural due process argument here.
Okay. No, I understand and acknowledge that. And if I had known, I had never been down this course before, obviously, and had seen this case law where this was done, and they made the efforts to tell the court that they should, vacate the judgment and re-enter it to give them a new time period to appeal. I might have gone down that course or that avenue instead. Obviously we're here now. And if this court isn't inclined to take it upon themselves to create a remedy, then, I'll certainly go down that path.
But I see you have a couple more minutes. Anything additionally?
No, I think I'll rest on that. I think it's a pretty clear and limited issue, and there's not much more to be said. Thank you.
Thank you. Attorney Manganaro.
Yes, good morning, Your Honors. Kevin Manganaro on behalf of Wells Fargo Bank as trustee.
What do you say to the fundamental fairness argument, which is how can this be fair?
Your Honor, we do recognize that having these sorts of jurisdictional limits, any sort of statute of limitations issue can sometimes create harsh results. But here, our suggestion would be that where the statute is so expressly clear about the nature of the limited appeals period, that it is jurisdictional, and there's no wiggle room here, for lack of a better term, for a trial court in this situation.
Understanding that position, what would you have your brother do? Would you say it was incumbent upon him to check every 7 days for 6 months or until the judgment issued?
I certainly don't want to impute any standard of practice to Attorney McCardle or to anybody. I can tell the court that I practice in the housing court, as I know Attorney McCardle does, and I do have weekly reminders to check the dockets in various cases to see what the status is. The housing court can sometimes be an unruly place, and sometimes decisions do take a long time to be entered. Some of that is by, I think, function, where there are a large number of emergency matters that come into the housing court on a regular basis, and therefore something like a summary judgment motion for possession can get put on the back burner for some time. So I do have a practice of checking the dockets regularly. Yes.
May I ask, like, it's outside the record, as your brother recognized, but is this a common practice in this is Northeast Housing Court?
It is Northeast Housing Court, Your Honor.
Is this a common practice of attaching a CC page to an order or a judgment that indicates who it was sent to?
I personally have not seen that in practice, Your Honor. I can't speak to what this particular court does. I personally have not seen that before. No.
Okay. I had a question about the Kobayashi case, which you cited in your brief on page 11. In Kobayashi, it was a summary process case, but the court said that due to the, I think the kind of complex issues that were presented, it lost its fast track identity. And so the court decided not to apply the 10-day appeal period. Given that in this case, the issues were evidently complicated enough that the judge wrote a lengthy memorandum of decision and didn't issue it until some 5 months after the summary judgment argument. Could we apply the same rule in Kobayashi and say this case lost its fast track identity, the summary process appeal period shouldn't apply, it should be the regular 30-day period of the civil?
I don't think so, Your Honor, because I don't believe that in the Kobayashi case, the loss of the fast track status happened because the case was factually complicated. Rather, I think it was procedurally complicated. If I'm remembering that case correctly, it was consolidated with a breach of contract claim that was not part of summary process at all. So through that consolidation, the case was in essence removed from summary process. So I think the holding in Kobayashi is merely acknowledging what happened procedurally through the consolidation of the cases. So I know we're only here on a limited issue, but I did just want to highlight our main argument, which is that the plain text of Section 5 requires the notice to be filed no later than 10 days from the entry of judgment. And indeed, it is the entry of judgment that triggers the 10-day appeal window, not notice to any particular party. So the plain text of the statute is very clear on this issue, that it is the entry of judgment, which is something that is reflected on the docket, which is available to everybody and indeed the public, that triggers the appeal period. It's not notice to any particular party. So the question of whether the notice was mailed or not is in large part irrelevant, because it is not, that's not the function that triggers the appeal window under the plain text of the statute. And I would also highlight that this court has numerous times reflected that the 10-day appeal window in Section 5 is jurisdictional and cannot be extended, even if that were something that the housing court judge were willing to do. I point to the several cases in our brief, and this court, as recently as May 15th, has affirmed the fact that Section 5 is jurisdictional and cannot be waived in a case called Glendale Associates versus Harris. The citation for that is 97 Mass App Court 454, and that's at note 16. So there is a large body of case law on this issue that is quite clear. The other case that I would point the court to that wasn't cited in our brief because it's a Rule 128 decision is Jamaica Plain Nonprofit Housing versus Reynolds. I apologize, I only have the Lexis citation for that. It's 2007 Mass App Unpublished 485. And that was issued on July 31st, 2007. And in that 128 decision, this court says that even in an instance of excusable neglect, the 10-day appeal window cannot be waived under Section 5. So simply put, we don't think the judge had any discretion here, even upon a sympathetic case.
Counsel, do you think the judge had discretion to vacate the judgment and enter a new one?
I'm sorry, Your Honor, I couldn't hear you.
Do you think the judge had discretion to vacate the judgment and enter a new one?
Candidly, Your Honor, that's not something we'd considered. I would simply say that it's not before the court on this appeal. And frankly, it's not something I looked into in preparing for today. Unless there, I did just want to touch on the constitutional issues. At the federal level, there's no federal constitutional problem here because the federal constitution does not guarantee appellate process in state courts. We cite to Griffin versus Illinois in our brief for that proposition.
Griffin says that, sorry, there's some background noise here. Griffin says that states are not obliged to set up a system for appellate review, which is certainly true, but once it has done so, it's obliged to administer it in a way that's fair to everybody. So
yes, Your Honor.
What's your position?
Your Honor, I would say that the 10-day window is applicable to everybody. I would say that what the housing court did here is just a neutral application of the general statutory guideline that applies to all litigants.
Notice was only sent to one party.
No, I would not stipulate to that as a factual matter. I know that Attorney McCardle has pointed to these sections of the record appendix. I do think it's an open question if that entirely means that. So I would simply say that notice is what's not required to trigger the 10-day window. There's no mention of notice in Section 5 at all. So it is the entry of judgment on the docket that is the triggering factor here. And I would again say that because the statute is so clear and it applies neutrally to all parties, that the judge simply applying that statutory limit does not create a constitutional issue. Unless there are other questions, we will rest on our brief and we ask the court to affirm the Northeast Housing Court's denial of the appellant's motion to file a late appeal.
Hearing none, the matter stands submitted. Thank you both. Thank you all.
Thank you very much. This is a case, and I know you've read the briefs, but I just want to give you a very brief overview of this. This is one seeking judicial review of a decision of the reviewing board of the Department of Industrial Accidents, which denied the town's claim that the 2-year limitation period set forth under 452 CMR section 3.03 subsection 3 applied to this case. And just by way briefly of background, the person involved in this case, an employee of the town of Adams, died in 1976. Benefits have been paid by the insurer to the daughter of the deceased since that time. This case is really one which revolves around the payment of cost of living adjustments that were made by the insurer over the years. Back in 1992, we learned that the town of Adams had been withdrawn from the trust fund as a participant in the trust fund as a result of actions taken by its insurance company at the time. The insurer
was that a strategic move by the insurance company?
I personally have no knowledge or information about it. I wasn't made aware of it until this litigation started, that it even happened. But what I do know is that the insurance company back in 1992 made the decision to withdraw the town, a public employer, out of the trust fund. And if you read the paragraph that governs what happens when a public employer is withdrawn or withdraws from the trust fund, it becomes liable for reimbursement at that time.
Would you agree that there are advantages and disadvantages to being a member of the trust fund?
I would assume that there would be. Yes.
And so can we infer that there was a strategic reason that they chose to withdraw from the fund?
I would assume that there would be some strategic reason, but I can't speculate on it. I mean, everything revolves around cost, I would assume. And perhaps someone made the decision that this would benefit from a cost standpoint coming out of the trust fund. But so I can't.
If that's true, then to treat them differently, that is, those members of the trust fund and those who opt out, wouldn't be an arbitrary and capricious act, would it?
Well, I think it would be arbitrary and capricious because I think there's many other reasons why you would want to treat them alike. I mean, over the years, you know, towns have to develop budgets, and much like the trust fund, when it develops the budget and all the things that it needs to do, towns have to develop municipal budgets. These have been very tight times, and I'm not specifically referring to what we're dealing with right now, which is particularly difficult, but in past times it's difficult. So to say that we will exclude public employers, non-participating public employers from the benefits of the 2-year limitation period because, while a strategic decision was made back in 1992, is completely unfair to the town because it needs to make its own budgeting decisions. It needs this as well as the trust fund. So
I take it this is part of your argument that there's no rational basis for distinguishing between the trust fund and the towns as ultimate sources of funding, your constitutional claim?
Yes, that's correct.
Yeah.
That's part of the rational basis claim.
Did you raise a constitutional claim before the Board of Review?
It was not presented to the Board of Review in that fashion. It was presented on the basis that the statute itself, section 65(2), explicitly permitted the use of the 2-year limitation period because it says itself that these claims for reimbursement would be otherwise, claims for reimbursement against public employers, non-participating, would be treated and subject to reimbursement under clauses A through G under section 65. So there's no difference between the way the statute treats it.
Let's focus on that language for a minute. It says the public employer shall be required to reimburse its insurer for any payments the insurer makes on its behalf that would otherwise be subject to reimbursement under clause A, which is the one we're dealing with here. So doesn't that phrase that would otherwise be subject to reimbursement under clause A suggest that the reimbursement this section is talking about from the public employer to the insurer is not under clause A?
Well, it would suggest to me that if the claim for reimbursement is being made under any of the clauses from A to G, that it would be subject to the same treatment as it would be if it were a claim made against the trust fund. That's my interpretation of that statute, is that it's to be treated the same as if you were making a claim for reimbursement against the trust fund.
But it's not a claim under clause A, is it?
Well, it purports to be a claim under clause A, yes.
It's a claim that if it were made against the trust fund would be under clause A.
Right, but it's entitled to treatment as the same. What I'm saying to you is it's entitled to the same treatment as if it were made against the trust fund. That's what my point is. It shouldn't be treated any differently than if it were a claim made against the trust fund. And as we know under Beatty's case basically says that the commissioner had the authority to promulgate this regulation. There is a 2-year claims presentation requirement under these circumstances.
What is unreasonable about the Board of Review's interpretation of the statute that is contrary to yours, that where the language says payments that would otherwise be subject to reimbursement under Clause A indicates that the payment we're talking about here is not itself under Clause A and therefore is not subject to the reg?
My interpretation of the Board of Review's decision is that they ignored the language that is contained there that would be otherwise subject to reimbursement. They are treating this claim as one that can only be made against the trust fund. So as a result of the way that the claim is being treated by the Board of Review as one is being made against the trust fund, then you know that seems to be the error that was made.
Hold on one moment, please.
Excuse me, I'm sorry.
And I did tell him that if there was anything we disliked, that we would either make the changes or.
I apologize for that.
That's
no problem.
Okay. But I don't know that we corrected it yet.
Oh, sorry. I hope that's better. I'm sorry about that.
That's much better. Maybe you can pick up where you left off about 45 seconds ago.
Well, what I was trying to point out is where I think the Board of Review's decision was in error about its analysis of that is that it's the position that it's taking is that this particular statute only applies to claims for reimbursement against the trust fund. And what I'm trying to point out by the language in this statute is that is not true. That particular paragraph allows claims for reimbursement against public employers and says it's subject to the same limitations, subject to the same reimbursement, disbursement issues as you would have under clauses A through G. Now, for example, if you made a claim against the trust fund under these circumstances and the claim was made outside the 2-year period, your claim would fail.
Right, but doesn't that speak to whether or not the COLA payments are reimbursable?
It does speak to that, yes.
But not necessarily the time frame. Is it true that if you're a member of the fund, you may have some administrative costs or fees that you would not be subject to if you weren't a participating member?
You're correct about that. You would have, but if you're also a public employer, you still have administrative costs that you have to deal with respect to dealing with this, as well as planning your budget and dealing with issues that you have over the course of the year. Excuse me for a moment. Apologize again for that.
That's okay. This is a new way of doing business for us all.
Well, sometimes you have issues like this that you don't foresee. So with that, I would respectfully conclude my argument and ask that this court reverse the decision made by the reviewing board of the Department of Industrial Accidents. Thank you.
May I ask Mr. St. John one more question? Do you contend that there are words either in the relevant part of the statute or in the regulation that are ambiguous in a way that would help you?
Well, my contention is, I mean, I don't think the statute, if you're saying that the section that I've quoted to you somehow doesn't apply and is only applicable for claims for reimbursement against the trust fund, then there is some ambiguity in the statute that leaves it for discussion and leaves it open for other interpretation. I mean, my interpretation of the statute is that it should be applied for everybody across the board, whether you participate in the trust fund or not, as a public employer. This to say that the the statute that, or excuse me, the 2-year limitation period should not apply to a public employer because, well, you're not part of the trust fund, you opted out, would seem to be, contrary to elements of fairness as well as, the equal protection argument that I've made previously, and would seem to be somewhat ambiguous.
And can you point to any particular word or phrase that's ambiguous? Because that makes a difference in how we treat the reviewing board's interpretation of the statute.
I'm unable to point to that now, other than to say to you that that's what I read in the statute.
You make some mention that the town didn't become aware that MIA had withdrawn from the fund until sometime after the fact. Had the town known when they actually did withdraw, would the town have done anything differently?
I can't even speculate on that. I wouldn't have any idea. What happens is something like this doesn't get brought to your attention until, as in this case, a letter comes essentially out of the blue from somebody saying you owe us, $100,000 or $150,000 for back COLA payments. Where did that come from? How did this happen? I mean, the town is, I'm sure somebody in the town must have been aware that Mr. Gaines had passed away back in 1976, but this did come out of the blue as far as learning back in April of 2016, there was something of this nature happening. And the town's position is why was this never brought up previously by the insurance company too? Because, they were in a situation where they were making payments, the trust fund had already turned them down, and they still sat there and continued to do it until they decided to turn their focus on the town in 2016.
Well, the trust fund seems to have missed it too. Didn't they make some payments for one of these periods?
I think they did for a year. I agree with you. I'm not here to point fingers at the trust fund. And I'm not really pointing fingers at the insurance company because I don't think that's really part of the case, as much as to say that, it's an interpretation of the statute, and it's a matter that what I'm asking you to do is to grant equal protection to the town as far as the application of the statute, application of this particular 2-year limitations period that's found in the regulations.
I think we understand. Thank you.
Thank you, sir.
Attorney Uline?
Yes, thank you very much. My name is Fred Uline, W. Frederick, and I represent Arrowwood Insurance Company. Appreciate the opportunity to address you. However, frankly, I think that everything I heard in the oral presentation is covered by the review board and by our brief. So I might be brief in this response. It certainly is a strategic move by the agent of the town, the subsequent insurer, to opt out. That saves them something that might equate to 4% of their workers' compensation costs annually as a add-on cost for paying for the administration of the department. They unfortunately didn't have good communication with their subsequent insurers, so didn't understand perhaps, but we're not responsible for that. The trust fund compounded the problem by paying us, I think, for some 10 years when they could have refused to pay us, and we would have then gone right to the town of North Adams for reimbursement. The arguments he made about are really public policy arguments, and they would have been better made when the regulation was being put in effect before the administrative body or before the legislature. They knew or should have known that this obligation was there, and sort of like pension obligations, Your Honors, they could have actuarially provided for this exposure way back when. They didn't for whatever reasons they are stating, they didn't. And nevertheless, they're still responsible for this payment, like they're responsible for pension payments. So I'm going to rest on my briefs and the reviewing board's decision, which is entitled to significant deference. Thank you.
Thank you. Hearing no additional questions from the panel, we appreciate it. The matter stands submitted. Thank you both.